everyone, this is Abhya, your in-house fashion lawyer and your host for Briefly Speaking by Regally Legal, your go-to destination for bit-sized insights and bold conversations that unravel the world around us. From the realms of fashion and law to everything in between, this truly is your one-stop for it all. And today for episode 3, we have someone who clearly doesn't need an introduction in the Indian legal profession. From being elected thrice as the president of the Delhi Bar Association to serving as the co-chairman of the Bar Council of India and now shaping the future of the bar at the national level, we have with us Shri Ved Prakash Sharma. He is someone who has dedicated his entire life to strengthening the legal profession in India. His judgment, reforms and leadership have had a long-lasting impact on how young lawyers and law students perceive the legal field. So without further ado, let's dive right into the podcast. Thank you so much for being here.
Thank you, Abhya, for having me in this program.
Thank you so much, sir. And it's on special request as well. We've been going back and forth with conversations, and I feel like now is the time. We have so many questions from so many students, law students, lawyers, that, just wish to get it from the co-chairman of the Bar Council.
So my privilege to respond to all your queries.
So I think without further ado, I'll go right into the podcast. So before the podcast, all the questions are based on an online survey that is conducted on our platform, Regally Legal. So these are questions from students, again, very enthusiastic law students and lawyers and young lawyers for you. So I think we're going to go right into the podcast now. So the first question for you is, I want to start with, again, something very basic, but I think this is also very, very important. You have seen the legal profession in India evolve for over 4 decades now. So when you look at the new generation of young lawyers entering the profession today, what, in your opinion, is the single biggest challenge they face today and what was probably not the case, say, 4 decades ago?
The true challenge is not lack of work, lack of a true mentor. It's very, very important. When you come to litigation, you must have a friend, philosopher and guide who can lead you to perfection. So a mentor, a guru, a ustad, it's very, very crucial in this profession because somebody is to be there to guide you to the level, you want to reach, the aspiration for which you have or your family has. They have sent you to this profession. So having a good mentor is the biggest challenge. In our time, when we joined the profession, it was not a big problem because the size of the bar was not too big. I joined 30,000 bar. At that time, the total number of advocates working at that place, it was the biggest bar of Asia at that point of time also when I joined the profession. But it was no difficulty for me to find a good senior or mentor, which you call it. But today, with the number of advocates in Delhi, it is more than 2 lakhs.
Yes.
So finding a good mentor, a senior, is a very, very crucial stage for new entrants in the profession.
So I think it's also the starting stage. So it's very important to have someone who is not only your mentor, but also, like you correctly said, your friend. Someone whose, helping capacity goes far beyond just...
Yes, there I do agree with you. And, these junior advocates, I never call them my junior. I always call them my junior colleague. So you have to give them love. You have to give them affection also. Only then you can guide them to the perfection. So they have to be given due respect also. And no doubt the junior colleagues shall give the respect which is commanded by the senior. So it is a mutual kind of thing. So they should never be regarded as something, like employer does with the employee. They are your junior colleagues in this profession. Remember, it is very, very important for us to remember. For all the seniors, for all the juniors.
Absolutely, sir. 100% agreed with you on this. Now, so the next question for you is, so recently there's been a lot of debate around lawyers advertising their judgments, which have been completely prohibited and restricted. While many law firms still showcase their work openly on LinkedIn and on social media, some say it builds credibility, others call it a violation. So as the co-chairman of the Bar Council of India, if I had to ask you, with the day and age that social media is in, do you think it should be considered as a threat, or it is something that we can probably find a middle ground?
Legal profession is not a trade. It is not a commerce. It is not a business. Okay, it's a profession to serve the people. So there can't be scope of any kind of competition. Justice V.R. Krishna, long back, he made a statement on the judicial side in a judgment that this level of commercial competition in the legal profession should not vulgarize the bar.
Yes.
The legal profession.
Yes.
So it is, and that is why there is a rule 36 in our rules of professional ethics and conduct framed by Bar Council of India. It is prohibited.
Yes.
Any kind of advertisement, publicity through any mode, it is prohibited. And violators of this rule, they can be punished under Section 35
Yes.
or professional or other misconduct of the Advocates Act. And we are taking action. In so many cases, matters pending. I am chairman of a DC. So I have so many matters before me where notices have been issued by the State Bar Council to these people. They come in appeal. Action is taken by the State Bar Council. Appeal lies to Bar Council of India. So they come in appeal. And very big law firms, partners of big law firms, well-established advocates, they also falter in this area. And they are attracted into giving advertisements on online and sometimes even on billboards. So it's not a profession, where which thrives on billboards or on advertisement or on publicity. This profession thrives on reputation,
Absolutely.
on goodwill, on your hard work, on your perseverance. All right?
Exactly, sir. And I think so few years back, it was not so bad. I feel like today, because I'm very active on all social media platforms, I see LinkedIn and I see law firms posting constantly, not just about very basic details, about judgments, about their wins, comparing it to another law firm's losses, and then saying that this is our work and we put it.
Yes, Abhya, it's a very serious violation.
Absolutely.
And action needs to be taken against all such people who are indulging. It is actually because of social media. The growth of social media is resulting. I have seen recently, last week, I saw somebody, he got a bail from a court. And the moment he got the bail, he came to his office and he prepared a video and he, posted on his Facebook that I attended this court today. I got a bail in this sensational matter, and it took me 40 minutes to convince the judge for getting me bail. Now, this is nonsense. We can't enter this kind of a competition. And I tell you, this when I became member of the Bar Council of Delhi, in way back in 2003, 2004, we got complaints, against advertisement being done by some advocates. So I was very eager and curious to see what is the philosophy behind this. What is the philosophy? So do you know the rules, Bar Council of India rules, they were framed by, stalwarts like MC Setalwad in those days, C.K. Daftari, Ram Jethmalani. So I happened to meet Ram Jethmalani in Delhi High Court. I asked him, sir, you are a framer of these rules of Bar Council of India. So I want to know why this rule 36 against advertisements. When we go to Europe, we go to America, we see huge holdings on the roadside by advocates that guaranteed and all those things. So the reason he gave was very, very convincing. And I was really moved by the answer Mr. Jethmalani gave to me. He told me with the C, in India, 80%, 85% advocates are doing their practice in taluka courts, in district courts, in far-flung interiors of the country. They can't compete with, affluent lawyers.
Yes.
They can afford to give advertisement. They can spend money on advertisements. So in order to have a level playing field, and plus than what he's also said, what Justice Krishna here later on said in a judgment, that it is not a trade, it is not a business. It is a profession meant to serve the people, not yourself.
Exactly.
All right?
And socially law.
So that is why this rule was framed, Rule 36, to be very specific, and it is prohibited. And any violator of this rule, they have to meet, the fate as given in Section 35 of the Advocates Act, and we have taken action in the past against so many advocates. And even currently, even Bar Council of India has suo motu issued notice to many law firms, well-established law firms also. So they are faltering at that.
The most established ones.
Yes.
Because I see, and I'm just in awe of every.
So I would not name anybody, but it is reprehensible.
Yes.
It is condemnable that people, despite there being a rule, we advise every young advocate who is enrolled by the State Bar Council to first read, it's an advisory given to the State Bar Council by Bar Council of India. That when you enroll advocates, you must hand over to all the newly enrolled advocates a copy of professional rules of professional ethics and etiquettes framed by Bar Council of India, so that they can learn how they are to conduct themselves in this profession. So if this is done, they would know that this advertisement, it's a vice, and it should not be, indulged in by anyone. In those rules, we have also framed, how the advocates are to conduct themselves vis-a-vis their colleagues, vis-a-vis the court. How should be they conducting themselves with their clients, their own clients, their clients of their adversaries. So it is all framed by Bar Council of India, and the young advocates, when they enter the profession, they must go through these rules and regulations framed by Bar Council of India, so that they don't face any embarrassment or difficulty later on for violating.
Absolutely, sir. If it's done at a primary stage, then it's the best thing possible for everyone going together. Yes. On that note, sir, I think I'm going to go into the next question. So there's one word that I've heard anytime I've spoken to any student, law student, young lawyer, just about anyone, and that's the infamous word of stipend. Whether in internships or junior roles, the story is the same: overworked, underpaid. So do you believe internships or entry-level positions should have a minimum stipend requirement? And if a student or a junior lawyer someday feels that what they are being paid is not justified, how can they raise their voice? Can the Bar Council of India really help them take this into consideration, given how long and intense work hours are, especially in our field?
No, most recently, there have been even judicial pronouncements by some high courts about, this stipend or whatever you call it, remuneration for junior advocates. For interns, I don't think there is going to be any concept of stipend, because it is part of their curriculum. When the intern come in one academic year, 130 days, 1 month is to be spent by every student as an intern. So they come here to learn, and they should not expect any kind of remuneration or stipend, in my honest opinion, because after all, the senior would be sharing his learning with those people, so they will get something from the seniors or any advocate they are working with as intern. So, but when the advocates, whom I call junior colleagues, if they are there, they are also there for learning. When we started our profession for 2 years, I was with a senior colleague. I did not get even a single penny. I was happy with whatever amount of learning I was getting from a chamber. It was a big satisfaction to me. And he used to treat me like a son. My senior, Sardar Gyan Singh Bora, I am naming him. He treated me like a son, but did not pay anything, because this was not the custom in those days. The thing was that you are going to a guru for learning, rather it is the Sish, who is learning, he has to pay some guru dakshina. But this is our culture.
Achha.
But now, since these juniors, they come to the chamber of a senior colleague, they work there for a year, for 2 years, 3 years, at least after 1 year. If somebody wants to stay in the office of a senior colleague, out-of-pocket expense must be paid to him. And we have issued advisory, to the advocates community in the country, the senior colleagues in the bar. They must take care of these needs of the junior colleagues. Of course, the initial years, they are years of suffering and struggle. 2 years, 3 years, like we did in our time. But then we established ourselves, and then there was no looking back. You must have heard some seniors telling that in the beginning, when you enter this profession, in the initial year, there is no work, no money. No. After some time, some work, a little work, little money. Then good work and good money. And a stage will come, no work and only money. That is for the seniors, like Kapil Sibul. So the juniors will come and brief him, and he will simply, go to the court and make his submissions. Only juniors work. These people don't work. I mean, this is the general on the lighter side.
Definitely.
But then it is a very important issue. And since, there was a time when advocates, profession was entered into by people from affluent family, from people who could afford, in the profession in their initial year, 3-4 years without any expectation for money. But now, the people from all state of life, they are entering the profession. We are 26 lakhs today in the entire country. And students, from humble families, they join the law course, they become advocates. So they must get something. You may call it remuneration, stipend, or out of pocket. They deserve it. Yes.
Absolutely, sir. Couldn't agree with you more on this. But sir, again, one thing I definitely like to mention is that whenever I've had a conversation with any young lawyer working in a law firm, they feel that जितना उनसे काम करवाया जाता है उसके हिसाब से जो शायद उनको compensation मिलनी चाहिए in any form. Like you said, the basic expenses, they feel that is their motivator. I come from that point of view, 100% agreed with you on everything that you said, sir, because at the end of the day, any law firm, any mentor to you is your guru. And having that respect without having to, have that thing that you need anything in return is also there. But sometimes with students, law students, young lawyers, they need a motivator, which for a young lawyer can come in the form of remuneration or stipend. So I think that might be one area.
We have not framed any rules, and there is no requirement, imposed by the rules framed by Bar Council of India as far as payment of this stipend or remuneration is concerned. But I would caution, these young members of the bar that if they are there, say, in a particular office, say, for 3 years, 4 years, upward of 5 years, they must expect, this motivation incentive should always be there. And the runners of the law firm, they should think about it very seriously. But if you are there, for learning purpose, say, for 1 year, 2 years, then forget about this remuneration. You concentrate, focus on the learning part of it. That is most important. And you stand on your own. Then after you start your own law firm, you achieve that level that you are able to start your own law firm. Okay. So it is, according to me, it is not an issue of very fundamental importance as far as this profession is concerned.
So there's a very common line in Indian families that goes by, we want our child to either become a doctor or a lawyer or an engineer. Many students then enter the law field not out of passion, but out of parental pressure. So if you had to give one straight up disclaimer to every parent and student, more so like only join law if ... like a warning sign for just everyone, what would that be?
Patience. Have patience. It's a profession, for in the initial years, you have to have patience. This profession is not a profession of immediate success. No immediate success in this profession, and the success in this profession would come only after patience, hard work, perseverance, and a lot of learning. So there is no substitute for hard work. So my advice, to all, students who are willing to come in this profession would be, when you enter this profession, be patient for some years, for some time. Like we did,
Manji.
Everybody did this. Whosoever is successful, you name anybody, in the initial years, everybody struggles. So these years of struggle are years of learning. They are years of learning. I would call them years of learning. So you should be happy with whatever you are learning. With patience, of course.
With patience. Sir, easier said than done. I feel me also personally, if you asked me, when I had initially decided that I want to do law, I want to become a lawyer, there's nobody in my family that is a lawyer. we come from a completely different set of family. And at that point of time, also 5 years back, just one thing my grandfather told me, that if you think you are going because, जैसे हमें television पे दिखाया जाता है, lawyer, law codes, judges, everything. It's not like that, especially in India. Yeah. So उस mindset से जाना उस चीज में I think is very important, and patience is the key.
Of course.
100%.
It is a key word, I tell you.
Sir, so the next question for you is, so I'm someone who's deeply invested in intellectual property. I want to ask you this. So outside India, we see AI, mainly tools like ChatGPT, transforming the legal profession, and they're being used in research, drafting, etc. And there was a very recent study as well that stated that the adoption rate of these AI-generated websites is quite high in abroad. Do you think AI is going to be a tool that benefits Indian lawyers anytime soon? Or if you think so, or if you don't, should young lawyers prepare for it as a friend or as a foe?
Abhya, I tell you, there can't be any substitute for human brain. All right. So AI, yes, it is being used extensively even in this legal profession. And it can be used as an assistant in your office. All right. You use it for, say, drafting. But for legal research, it is a failure. It's a failure worldwide. The kind of citations which AI chat GPT is given, people end up giving these citations in their written note of arguments. They will write a, AI or so-and-so, Supreme Court cases so-and-so, and it is on a different aspect. The judgment is not the issue which you are dealing with in your written arguments. It is something else. And judicial side, last week, a comment was made by a high court that why are you going to AI for this, giving this precedents which do not exist at all. So it has to be a very, very, nothing is infallible. So AI is also not infallible. So it can commit errors, it can commit mistakes. So you make a double check, you make a recheck before relying upon AI. And as I said, human brain is the best. There is no substitute for it. All right?
Yes, 100%. Yes. And so like you said, usually there are a lot of errors and mistakes that are there. Sometimes in my university only, I saw so many, but this is at a student level. They used to just submit the essay or whatever that was, being asked.
And then get a lot of embarrassment.
One of my friends actually also faced it. Again, you don't check. You blindly just trust AI or ChatGPT so much that you think that this is going to be 100% right because it's machinery using brains and, so many data stored in it. But it's not accurate all the time. And
it will never be
accurate.
So you rely upon yourself, your own brain, your own expertise, your own ability. You can take assistant of AI, no issue on that. No issue.
For summarizing and all of it, I think
yes,
it's very...
as far as drafting is concerned, your correspondence, sometimes pleadings also, you can get a good help from AI. No doubt about it. No doubt about it. Yes. You can improve your language also through AI.
Sir, so the next question for you is, this one's also a little personal. When I graduated, even though I had good grades, I felt completely clueless about what to do next. Where do you start? How do you decide between litigation, corporate, intellectual property, criminal, policy work? There's so many areas. Many students feel the same confusion today. What's your advice for them on how to find their focus area? Is there any structured support that the Bar Council can probably provide for a student to feel more secure right after they graduate?
No, I tell you very frankly, it's a question of great interest to me. I really love this question whenever it is put to me. In my opinion, litigation is the soul of legal profession. Practice on the litigation side. Because the purpose of the profession is to serve the people. And how do you serve the people if you get them justice? It is a fight for justice. People are coming to you. It is part of that. So litigation is the preferred area which I will advise to everyone. And in litigation, I tell you, we have a lower courts, we have high court, and then Supreme Court. Everywhere we have litigation, lawyers on the litigation side. Litigation, as I said, is the soul of legal profession, and practice in the trial court is the soul of litigation practice.
Okay.
So when young lawyers enter this profession, they must start with the trial court. Trial court means where you get opportunity of examining witnesses, where cross-examination of witnesses, and which is the basic fundamental, ground of laying down your pleadings, which is the foundation of the entire litigation, which may go up to the Supreme Court. So it's an area of great responsibility working in the trial courts, and it is the most important area of litigation practice. Trial court, start from the trial court, then slowly and gradually you can go and establish in the High Court, and of course you have Supreme Court there. So you must, and as far as this corporate practice is concerned, it's a matter of great worry and concern, at least for many people like me. I am on the governing board of NLS Bangalore and also NLU Delhi. And in our executive council meeting, governing body meetings, I always ask the vice chancellor how many students are going to litigation after doing and completing their law course. The number, is very, very miserable. In litigation, hardly 25 to 30% students go for litigation, get themselves enrolled with the State Bar Council. Rest of them, they are picked up, it's a cherry picking by corporate houses or big law firms, and they go for corporate practice because they get good remuneration. In litigation, there is, as I told you, there is a struggle in the initial years. But in corporate, they get, good salary packet right from day one. And many of them don't even go and get themselves registered with the State Bar Council because you don't have to appear in the courts. So you have simply to do all this amalgamation and whatever it is, this
out of court work.
Out of court. So but according to me, that is not a real legal profession. That is no advocacy. So my advice is that when you come to why this 5-year integrated program was devised by Professor Madhava Menon, who is known as father of modern legal education in the country. His idea was that right from 10+2, the student, the young man can make up his mind that I have to go to the profession, legal profession, and serve this profession right from day one. In earlier days, when we started after graduation, it was 3-year LLB, and it was the last and least preferred course. So somebody who did not get admission anywhere else, he would go to law. But now this concept is not there because of this integrated 5-year course. And the purpose, the idea of Professor Madhava Menon was that right from the beginning in your, say, 17-year or 18 years, you decide about your goal and you focus on that. And the idea was only to serve the legal profession on the litigation side, not to be a corporate lawyer, not to earn money. So it is only about money. As far as corporate practice is concerned, it is only to earn money. So my advice to the young entrants in the profession is that you focus on litigation, number one. You focus on trial court practice. And once you establish that, then you start moving to High Court and Supreme Court. So it is very, very crucial.
Important to
and important for the, yes.
Without having the corporate mindset from the start.
Yes, that is only a money mindset. This corporate practice is only for, because they get very huge package. So they simply go and fall in line with that.
And I think that's, sir, right after you graduate from your university only that students and...
I told you they pick up from the university from their final years. These corporate houses and big law firms, this is what I've been briefed by the vice chancellors of NLU and NLS Bangalore. That in the 5th year, they would come to what is called that campus, campus recruitment, and they will take away all these students. Most of them, almost 70% go for corporate. But this is not good for the profession. This is not good for the legal profession.
So sometimes it's also them kind of, not realizing the full potential. Maybe sometimes when you actually...
They have potential, they are getting very good education, legal education, standard of legal education. In some of the central universities, private universities, NLUs, it is very high. It is second to none. But unfortunately, these good students who are getting the best of legal education, if they are not turning to litigation to serve the people, the cause of justice, for which this profession was devised, according to me, this is unfortunate. Why it is called a noble profession. It is called a noble profession that we can serve the cause of the people while making private money also. That is also important, in this profession, as you said about stipend, all those things. So money part is quite important. But more important is the fact that you are serving the cause of justice. It gives you a great satisfaction. So money is not everything. All successful lawyers, who was the known lawyers in the country, it is not necessary that they have made a lot of money, but they have earned a lot of satisfaction.
And
They have, yes, respect and satisfaction. So it's very, very important. Money is not that important. All right?
So in any profession, money is important and all of that is there. But especially in law, the first priority can never be money eventually in your mind as well.
Exactly. You are right. I agree. Yes.
You've probably seen every kind of lawyer in your long career. If you had to pick one quality of a lawyer that makes he or she truly different and distinctive, then what would that be, which would probably give them an edge over anybody else?
A lawyer who is committed to the profession, who has the qualities of honesty, integrity. It is very, very important in this profession. And working with a sense of commitment to serve the profession, according to me, that is the best quality you can expect from any lawyer.
As basic, sir, as basic and as important as it is for anybody in the profession to
commitment for the profession. Profession means, again, serving the cause of justice for which we are meant.
Absolutely.
There was a provision in Punjab Municipal Act long back. It was a legislation which was enacted in 1800 or 70s that the houses owned by lawyers, they were not subjected to property tax. What was the reason? Because this is a distinct class. It was considered a distinct class who were serving the people, the poor people who were, fighting for justice. So this was the respect for the profession. That advocates, they were exempt from paying any property tax. Later on, it was removed, when this freedom struggle started and advocates started fighting, against these colonial rules. So it was removed, but it used to be there. And the only reason was that it earned a lot of respect for the professionals who are in the legal profession, for advocates, that this provision was enacted. So, but this reputation and this respect can only be earned if you work with honesty and integrity. So that is the most important feature every advocate must strive for.
Noted, sir. All right, sir. Sir, so the next question for you is, there was a recent statement given by senior advocate K.K. Menon in an interview mentioning the fact that over 90% of the lower court judges in India are corrupt. Who, according to you, are the fixers here, and what's your comment?
Mr. K.K. Menon is a senior advocate. He's a good friend of mine. He has been chairman Bar Council of Delhi. Currently, he is a member Bar Council of Delhi. He has been my colleague in the Bar Council for the last about 25 years. So, Mr. Menon, having made this statement, naturally he must be having some facts and figures, and he must have made this statement with responsibility. But talking about corruption in the lower judiciary, what about higher judiciary? We have to think about that also. And secondly, Mr. Menon has also said in this statement that the honest judges, 10% of the honest judges are suffering. What about advocates? My view is that honest advocates and honest judges, they are both suffering and suffocating. Yes, level of corruption, I can't say about 90%. I don't give any comment because it's a statement given with responsibility by Mr. Manan, but corruption is there. And then you raise the question about the fixer, because in this interview also the issue of fixer has come.
Yes.
Now, in my honest opinion, with due respect and regard to my esteemed colleagues in the profession, I would say that these who are the touts, the fixers, they are, among advocates only, even leaders of the bar. We have complaints. I am saying it with a great sense of responsibility. In Bar Council of India, we are dealing with many matters where leaders of the bar, elected leaders of the bar, complaints have been made against them by the judicial officers that he approached me with a offer of bribe. We have such complaints. So the fixtures and the touts, they are also from this very community. It is a issue, which must be addressed, and it's a issue which has been there. You may be knowing in 2004, Justice S.P. Bharucha, he was Chief Justice of India, and in a farewell function organized by Supreme Court Bar Association, he made a statement which stunned everybody. The media, the advocate, the judges. He said that 25% judges from lower court to the Supreme Court, they are corrupt. He made that statement, very sensational statement. But then corruption is there. There can't be any denial about it. But I must tell you one thing. If we reach the level of 90% corruption in the judiciary, then people will lose complete faith in judiciary, and they will start, deciding their disputes and conflicts on the streets instead of coming to the courts. Then where is the need of coming to the court if you can't just get any justice? 9 of 10 judges are corrupt, then where is the need to go to the court? Then decide your dispute, on the streets. So, but this is a very serious question, and it needs to be addressed with equal seriousness by all concerned.
Absolutely, sir. And even when I watched the interview, the first kind of thing that popped up in my head was this only, 90%. If the figure was somewhat maybe, what we all might, have assumed about corruption and the legal profession, it would have still surpassed that. But 90% is a huge.
No, I would not make any comment on that. Mr. K.K. Manan is a very responsible senior advocate, and he may be having certain inputs and facts and figures, so no comment on 90% part of it. But yes, corruption is there, and it's a a vice which has to be dealt with very, very seriously. So recently, incidents have happened. So many incidents. I am not naming anyone, but it's an issue of great importance, significance, and it must be addressed sooner than better. Before people lose faith in the judicial system, the judicial kind of functioning of the country, what's the use of then having these courts, then Supreme Court to the lowest court? What is the need?
All right, sir. Now we have the last segment for you. This is what we call as the legally fashionable segment. It's a very simple this and that. So we sit at the intersection of law and fashion. So it's just a fun round, sir, for you to pick from. All right, sir. So the first one for you is, what would you prefer, courtroom practice or bar council leadership?
Both. The reason, yes, I tell you the reason. The reason is that my conviction is that only leaders of the profession should be leader of the bar. So that is my conviction. And throughout my life, I have been a practicing advocate in the lower courts, in the high court. I'm a trial lawyer. I go to the lower courts even today. I am in the High Court also. So both are important, because the leadership of the bar is very, very crucial. It must be in the hands of only those who are practicing advocates. Okay?
Justified. Number 2, sir, bare acts or landmark judgments?
Bare acts are, of course, important, because bare acts contain the law which is interpreted by the Supreme Court in the judgments or other courts in their judgments.
Yes.
And, as far as judgment is concerned, the courts keep on changing their judgments every now and then. You will find the Supreme Court changing their judgments, every 5 years or 10 years, you will find a dissenting view, and the earlier judgments are overruled. So it is the law which is important as laid down and as framed by the legislature and as contained in the bare acts, of course.
Done. All right, sir. The third one for you is discipline in the profession. Stricter rules or more self-regulation?
Self-regulation is very, very important. Yes, we do have rules of professional ethics and etiquette, but I would be the happiest person that if lawyers realize, their duty to self-regulate themselves. And just we were talking about this advertisement part.
Yes.
So if they realize that it's their duty not to indulge in this kind of commercial sort of competition.
It will be very easy for everyone.
Easy. So there would be no complaints, no DC, nothing of the sort. So it's very important, self-regulation.
Self-regulation it is. Young lawyers need more mentorship or financial support?
Mentorship, most important.
Legal education reforms more practical training or stronger theory?
Practical training.
Practical training. Gen Z lawyers, more ambitious or more impatient?
Should be ambitious, of course. Ambition should always be there. Without that, you can't work. But they are getting impatient. I'm not happy about it.
We will definitely improve. All right, sir. If not law, politics or academia? Academia. Justice delayed or justice hurried, which is worse?
Justice delayed. Because if matters are pending in the court for, say, 25 years or 40 years, and there is no judgment given by the court, I would prefer hurried justice. You can go and challenge if you are not satisfied.
100%.
So justice delayed is very, very dangerous.
It's also the most
it's a reign of legal kind of system in the country.
Absolutely. Yes. Delay is actually the worst part of it. All right, sir. So bar exams once a year or twice a year?
Twice a year. We have framed these rules, and actually because of COVID, we were not able to implement it. But twice a year, it is good. And the students and the new entrants, advocates, they also prefer twice a year.
Twice a year. All right, so the last one is reputation of a lawyer built in the courtroom or outside in the society?
Both. In the courtroom, we have to showcase your ability and your competence, your effectiveness, your communication skills, your oratory skills. Outside the court, you have to be a gentleman.
100% justified and agreed. And I think, sir, more than anything else, when you're out of the court, there are more eyes on you. So I think the way in which you conduct yourself is very, very important and becomes very crucial.
Yes. I said one word, gentleman. You have to be a gentleman outside the court.
Done. So on that note, we come to the end of the podcast, sir. I just wanted to say thank you so much for being part of it. And all your valuable insights have been absolutely important, crucial for each and every person, young lawyer, law student listening to the podcast. And I personally have also learned a lot. So thank you so much, sir.
Thank you, Abhya. Thank you for this opportunity. Thank you. Thank you so much.